Forget New Year, New You. This season is about slowing down, locking the doors, and cozying up at home with the one you really want to do nothing with. Your dog. After the holiday chaos, those quiet nights with a blanket, a podcast, and your pup feel like the reset you actually need. Ollie helps make those moments easier with fresh protein-packed meals made from real human-grade ingredients, so your dog can enjoy some quality comfort food too. Choose from 5 recipes and get a personalized plan for your dog's needs. Meals arrive perfectly proportioned with a scoop and storage container, so serving is fast and mess-free. And with Ollie's in-app on-demand health screenings, supporting your dog is easy, ensuring more cuddles for many years to come. Visit ollie.com/truecrime and use code TRUECRIME for 60% off your first box.
Hey everyone, this is Jillian, and you are listening to Court Junkie. Today, I wanted to give you an update in the Michelle Carter case. So if you haven't yet listened to Court Junkie episode 29, please go and listen to that one first, as this one is an update on that case. Just as a recap, in episode 29, I covered the case of Michelle Carter, who was convicted of involuntary manslaughter after a jury found that she had encouraged her boyfriend, 18-year-old Conrad Roy, to kill himself. It was discovered that she had even been on the phone with him while he was doing it. At one point, he even got out of his truck, and she encouraged him to get back in and go do it. So Michelle's sentencing hearing was earlier this month, on Thursday, August 3rd, 2017. And the first person up to the witness stand was Camden Roy, Conrad's sister. She didn't address Michelle at all, but she spoke about the loss of her brother and how hard it's been on her. She said she was grateful for the 13 years they had together, that he was always there for her and was a great big brother. She said she will never, ever get over the pain of losing him. Conrad's father, Conrad Roy Jr., also gave a statement. He spoke about Conrad, who he called Coco, and his struggles with depression. He called him sensitive, loving, intelligent, compassionate. He said his sisters adored him and that he was an excellent older brother. He also addressed Michelle.
Although he did have some psychological troubles, we all felt that he was heading in the right direction and over the worst of it. Time and positive support from family and friends were critical to his emotional well-being. He had such a bright future. Michelle Carter exploited my son's weaknesses and used him as a pawn in her own well-being. She has not shown any remorse. The fact that my son was convinced to kill himself makes his death unimaginable. How could Michelle Carter behave so viciously and encourage my son to end his life? Where was her humanity? In what world is this behavior okay and acceptable? Coco is missed beyond measure. His family misses him, his sisters miss him, his friends miss him, and I miss him. The last words I said to my son was, "I love you." And Coco said, "I love you too." I miss him every moment of every day.
Assistant District Attorney Mary Claire Flynn then read a statement from Lynn Roy, Conrad's mother. She spoke about her pain, about her disbelief that Michelle could do something like this, and her hope for a new law so that no one will ever have to go through this again.
I do not know where to begin. When this became a news story, it completely overwhelmed myself, Conrad's dad, and our daughters. I have been doing my best to gain strength from Conrad's 2 sisters, and they gained strength watching me with doing my best to put one foot forward each and every day. It has been completely hard to be in certain social situations at times, feeling so broken. I have only been to a few court hearings, not that I didn't want to be there for my son, but I know that it's something that brings me more pain that I could not handle. I still cannot come to terms that another person who knew and described how much they loved my son would want to inflict so much pain on myself, his dad, his sisters, and all who loved him deeply. He is the most amazing human being and would have had a bright future. He should have been navigated into a positive direction. He certainly was, with his support from his family. He accomplished more in his short life than some do in a lifetime. I know deep inside my soul, and I think often of my son's soul, and what a beautiful, selfless soul he was, that he would never want us to endure this pain with losing him. But what comes along at his court hearings is that he believed that social media was corrupting his generation. It is unfathomable to believe why someone would want such an amazing, young, caring man and everyone who loved him to carry this throughout the rest of our lives. There is not one day that I do not mourn the loss of my beloved son. Every day I strive to be a better mother to his sisters and a better person for him. I want him to be proud of me and how I am handling everything. I am trying to be there for his sisters in the best way that I can with all of my pain that we will carry with us until eternity. This does not stop after a trial. I pray that his death will save lives someday. I said to myself, in honor of Conrad, I need to handle this in the best, graceful way that I can. Conrad always wanted to help others. I cannot put into words what an honor it has been to be his mother. I am very blessed to have spent 18 years and 10 months with him. Every day I will continue to honor him. I pray that a law comes forth that another mother does not have to endure what I am.
Flynn asked the judge to sentence Michelle to no less than 7 years and no more than 12 years in state prison. She said the facts in the case are egregious and said Michelle undertook a deliberate, well-thought-out campaign to cause Conrad's death. Quite simply, she said, for her own personal gain and quest for attention.
There is no earthly reason why Conrad Henry Roy should not be here today with his loving family, enjoying life, sharing his many gifts with the world, but he is not. And the reason he is not here is the defendant. Michelle Carter, her actions killed Conrad Roy. She ended his life to better her own. Now she has been convicted of a very serious crime, deserving of serious punishment. It is true that rehabilitation must be a part of any sentencing scheme. But in order to be rehabilitated, one must accept responsibility for their actions. To this date, the defendant has not accepted responsibility for Conrad's death. She has blamed it on his fragile mental state, his family situation, her right to free speech, or the medication that she was taking. She has shown no remorse, and in fact, after Conrad's death, it was quite the opposite. She sought attention and sympathy for herself. It wasn't enough that she took Lynn and Conrad Jr.'s only son, or Camden and Morgan Roy's older brother, or Tom Gamble's best friend. In the aftermath of Conrad's death, she continued to use and deceive all of them until she was caught by her own words. And I would submit to the court that had not the Fairhaven Police Department confronted her, she would have continued her charade as the grieving girlfriend, quite possibly forever.
She asked the judge to remember the text message that Michelle had sent to Conrad, saying she felt played and made a fool of by him because he hadn't killed himself yet. She said probation is not a reasonable sentence for all the pain Michelle has inflicted, nor would probation help her. She then talked about Michelle's prior mental health issues.
But another factor Your Honor must consider is the probation report, and I, again, and the Commonwealth agrees, it was quite a telling report. Certain things that were important for the court to note and that the Commonwealth took note of was that the defendant had an inability to be honest with her therapist, and there was a lack of awareness in her parents about what she was up to, what her treatment was, and what they should do in order to improve in not only her health, but other things that were happening in her life. They simply didn't know. Another factor Your Honor could consider is a lack or a success or lack of past treatment. And again, the records bear out she was not benefiting, nor did she follow through with her treatment. Many times she was recommended to go on to do further things, and when things weren't going her way, she and her parents stopped treatment altogether. This is not someone that can stay in home confinement and get better, or even understand the ramifications of what she's done. And of course, we read through the letters from the defendant's memorandum. And again, the Commonwealth is concerned that her support system just does not get the impact of what she did. And I say that because of the terms that they used in their letters. They say things like, she made a mistake. She showed poor judgment. She didn't comprehend the severity of her situation. She was helping Conrad to achieve his goal. They don't seem to understand it was her plan. She was the one on the other end, goading him, telling him to get back into that car. She was the one that for weeks berated him. She never told any of them that, and even after his death, and even to this day. She says she didn't know how to call an adult for help.
Flynn pointed out that Michelle was underage when it happened, but said she was only 3 weeks away from her 18th birthday. She wasn't, quote, an immature 14-year-old girl. All she had to do was say to get out of the truck, and none of this would have happened, she concluded. Michelle's attorney, Joseph Cataldo, then got up and spoke for Michelle. He said the defense is requesting that her sentence be 5 years of supervised probation with various conditions, including mental health evaluations and counseling.
As this court is well aware, we're guided with the idea in the juvenile justice system that the goal is not punitive, but yet rehabilitative. Ms. Carter was 17 years old at the time. We have a body of law from both the United States Supreme Court as well as the SJC about the adolescent brain development which a court can consider on sentencing. And there is the clear body that says adolescents are not as culpable as full-grown adults. Ms. Carter does not, I suggest to this court, pose a danger to the public. I suggest that this sad, tragic manslaughter that she has now been convicted of was a very unusual set of circumstances unique to these two individuals, Conrad Roy and Michelle Carter, who are both struggling with mental health issues themselves. Ms. Carter, as this court has seen, both from the probation department's report as well as through the course of the trial, had her own issues. She had her own troubles dating back to the year, going back 3 or 4 years to 2011, where she was inpatient and treated for various eating disorders. And she was put on antidepressants back at that time, which she remained on these antidepressants until the year 2015.
He said Michelle never had any kind of disciplinary issues or criminal history, and pointed out that she will have to live with this for the rest of her life, which won't be easy.
Ms. Carter will have to live with the consequences of this for the rest of her life, with the publicity that this case has gained. That will be substantial. I think treatment is appropriate in this particular case for Ms. Carter. Your Honor, you have in the various documentation that she's still in counseling, verified by probation, that Ms. Gail Holmes opines that she's not a danger to the public, and specifically, as the court saw, that Ms. Carter does regret what happened. She also sent a letter to the probation department where she accepts responsibility for her actions, her words, her letter. The court has reviewed all this. Your Honor, I suggest that she is not a danger to the public, and in the remedial system, the juvenile system, probation is appropriate.
He said that while Michelle was texting Conrad about his suicide in June 2014, she had been dealing with issues herself, her eating disorder and her own significant depression. He asked the judge to factor that in when he considers sentencing. Give her an opportunity to show the community and this court that this was a horrible circumstance that she completely regrets and does take responsibility for, he said. Judge Moniz then took a recess so he could review all the submitted materials and deliberate. When court resumed, he spoke to the courtroom and said that the most poignant thing that was said during the entire trial was by the prosecutor, who had said that this was a tragedy for 2 families. Judge Moniz said that he has not found that Michelle's age, level of maturity, or even mental illness had any significant impact on her actions. He said he must consider a balancing between rehabilitation, the promise that that rehabilitation would work, and a punishment for the actions that have occurred. And then Judge Moniz delivered his sentence.
Ms. Carter, a guilty finding have been entered on the indictment charging you with the involuntary manslaughter of Conrad Roy III, now sentences you to 2.5 years in the Bristol County House of Correction. 15 months of said sentence shall be deemed a committed sentence, and the balance thereof shall be suspended until August 1st of 2022. You will be on probation, administrative, until you are released from incarceration, supervised thereafter, and the date of probation commences today. While you are on probation, there will be the usual conditions of probation, which include that you will obey all court orders and all local, state, and federal laws. You will report to your probation officer as that individual directs. You will allow the probation officer to visit in your home or school with or without notice. You will notify your probation officer within 48 hours if you change your residence, school, or employment. You will report to your probation officer within 48 hours after you are released from incarceration. You will not leave Massachusetts unless you get permission of your probation officer and sign a travel permit. You are required by virtue of your conviction to submit a DNA sample, and that will be done through the probation department. You will sign all releases as necessary for probation to verify your compliance with its terms, and you will pay all court-ordered fines, costs, and assessments. Those are the general terms. There are, in addition, specific terms. You are to have no contact with any member of the Roy family, excepting only that as may be necessary in conjunction with any civil litigation, including but not limited to the matter of estate of Conrad H. Roy III versus Michelle Carter, docket number 17-0846. You will have no contact, direct or indirect, with any of the civilian witnesses who testified at this trial, excepting only Dr. Bregan. Upon your release from incarceration, you shall present yourself within 48 hours to the Bristol County Juvenile Court Probation Department, Taunton Division, and thereafter shall follow all regulations as indicated by that probation department as to reporting requirements. When you report to probation, you will arrange through probation to schedule a mental health evaluation, which will be done by our juvenile court clinic. Said evaluation shall be for the purpose of addressing areas of need as to any mental health issues and to make recommendations for the treatment thereof. You will be required as a condition of your probation to cooperate with that evaluation and to follow those recommendations. Said mental health services shall continue for as long as deemed necessary while you are on probation by the clinician or individual providing same. This court further orders that any disclosures made by Ms. Carter during the mental health evaluation or the treatment recommended may not be used in any substantive way at any subsequent evidentiary hearing that may occur relative to this matter to establish any of the elements of any crime, including this indictment, in the event that for whatever reason it is retried. Based upon this court's analysis, that to some degree, and drawing on Dr. Bregan's testimony, that he spoke in terms of behavior of grandiosity, and this court's assessment that for whatever reason, part of the motivation for this activity that led to your conviction was a sense of self-aggrandizement. This court now orders that you are not to profit from the events of which you now stand convicted and the facts surrounding same. For those counsel, I refer you to the case of Commonwealth versus Power, 42010, 410, and the cases that are cited therein from 1995. You, Ms. Carter, your assignees, and any representatives acting on your authority are prohibited from directly or indirectly engaging in any profit or benefit-generating activity relating to the publication of facts or circumstances pertaining to your involvement in the criminal act for which you now stand convicted.
After she was sentenced, Michelle's attorney, Joseph Cataldo, again spoke to the court. He told the judge that there are very important legal issues associated with this case and that they plan on taking it to the appeals court. He asked Judge Moniz to stay her jail sentence while the issues are sorted.
This court has already, and I won't go through each and every one of the motion for required finding, but I think this court is, it realizes that there are many issues in this trial and the uniqueness of a manslaughter without a statute for assisting suicide and the implications in the First Amendment that this case will have or could have once an appellate court ultimately rules on the First Amendment. So, Your Honor, the idea that even if the appellate court were to deny it, these are legitimate issues that are worthy of presentation, and it's something that the appellate court will ultimately may not rule on by the time Ms. Carter, if she is ordered to serve her sentence immediately, would already be out, would already be released. So for those reasons, Your Honor, we think that this court should issue a stay of the execution. She would be on probation immediately. She would have to do everything else and begin with all her conditions. But the incarceration portion could never be taken back if the court does not stay that particular issue. Further, Your Honor, as this court knows in issuing whether or not, in deciding whether or not to issue a stay, is whether or not Ms. Carter might be a flight risk. I think that is extraordinarily minimal in this case, that she would be a flight risk. She's always appeared in court for the past 2 years while this case has been pending. She has not defaulted. She has obeyed each and every term and condition of her pretrial release. I would suggest that she will go ahead and start with her probationary conditions, but just we're asking to stay the portion of the sentence that would dictate that she be incarcerated immediately. Your Honor, there are a lot of legal precedent, not just in Massachusetts, but from around the country, on the issues of whether or not speech without using true threats can be curtailed without a statute in place. These issues need to be litigated in an appellate court ultimately, and we're asking you, Your Honor, to stay the jail sentence until we can have our day in court in the appellate level of whichever court ultimately it goes to be the final arbiter determiner of the First Amendment, as well as the idea of the duty imposed on Michelle Carter and all the other issues on the motion for required finding of not guilty, some of which, Your Honor, were not presented on Commonwealth v. Carter, the SJC previously issued in 2016. There were some other issues, as this court notes. So for those reasons, I'm asking the court to stay the execution of the jail sentence of this case.
Judge Moniz told Cataldo that he had some concerns with that, and ADA Flynn asked him to deny their motion. The judge thought a few minutes before speaking to the court. He told Cataldo that he had been expecting that motion and had given it significant consideration.
I guess we have all come to know each other a little bit. I anticipated this motion, Mr. Cataldo, and I took some significant time to review the case of Commonwealth v. Hodge, which is found at 380 Mass. 851. I note at page 855 of that decision they are talking about the significance of stays, even though the reporter's notes indicate that stays are not generally the practice here in Massachusetts. It does say, however, that the practice of a stay is grounded in rudimentary notions of justice, that a person convicted of a crime who would a short sentence would otherwise be made nugatory in the case of a short sentence and would be impaired in the case of a larger sentence, and says further, citing Commonwealth v. Levin, 7 Mass App, Court 501, the conviction may be reversible, but the time spent in prison is not. I am satisfied, under the Hodge language, that there is an issue worthy of presentation to the appellate court. In fact, this court believes that the wisdom of the appellate court will be of instruction now and going forward. And that's important. And one of the reasons it's important, Ms. Flynn and Ms. Rayburn, as the representatives of the Commonwealth of Massachusetts, and specifically the Roy family, is the letter of Mrs. Roy, who said that she hoped that the death of her son would result in law that could prevent this from ever happening again. I don't know what the appeals court will do. I don't know if it goes to the SJC, what the SJC will do. But I am satisfied that a grant of a stay through the Massachusetts court system only is warranted.
And so Judge Moniz granted the stay, meaning that Michelle won't serve her time until her case has gone through the appeals process. So naturally, I had some questions about the sentencing, and so I reached out to Daniel Medwed again, the law professor at Northeastern University. In the judge's sentencing memoranda, he mentions Section 53 and Section 58, which to me were completely foreign to me. I had no idea what those were. So he basically explains that in Section 53, children charged with crimes are to be treated as children in need of aid, encouragement, and guidance. But then he says that he must balance that with something called Section 58. So I was hoping that you can kind of briefly explain what both of those sections are, what they mean, and then, kind of what he meant when he said that.
Sure thing, Jillian. Basically, Section 53 is a preamble to the juvenile justice system in Massachusetts, and it basically suggests that all of the rules related to juvenile justice should be liberally construed. That's fancy legalese for let's interpret the law in a way that's very lenient for kids. And what that section says is that the care, custody, and discipline of children should basically be the same as if they were with their parents. And we should treat children not as criminal, but as juveniles in need of aid, encouragement, and guidance. So it's a very holistic, positive expression of how the system should treat kids as kids and not as criminals worthy of punishment, essentially. So that's Section 53. Section 58 is counterbalanced somewhat against 53. Section 58 is the youthful offender statute in Massachusetts. And about 20 years or so ago, the state legislature developed a youthful offender regime that basically said that juveniles who commit serious crimes will be branded as youthful offenders and basically be exposed to the same type of sentence that an adult might face. This was part of the tough on crime movement and concerns about juveniles being very aggressive and very violent and causing lots of harm. So I think Judge Moniz was trying to balance those, to some extent, competing visions of juveniles who commit serious crimes. On the one hand, you have Section 53, which says we should be concerned about the care of children, we should encourage them. And then you have Section 58, which says youthful offenders are going to be treated virtually like adults.
Okay, interesting. That definitely puts that into perspective and definitely makes more sense now that I've heard you explain that. So one of his comments that I also thought was pretty interesting, and I don't know if anyone else would have this question, but he was saying that he did not base his decision on emotion. And basically he said that emotion has no place in the courtroom. I don't know if this is like a dumb question or not, but is that standard? Are judges required to keep their emotions out of it, so to speak?
I think it's a great question, Jillian. It's not that judges are required to keep their emotions out of it. It's just that there's a lengthy historical bias against emotion and in favor of reason in our legal system. For centuries, really, scholars have talked about the difference between emotion and reason and how if you're acting emotionally, it often reflects your feelings of the moment. And maybe you'll react aggressively or hostilely and make a decision that you regret. And I think to some extent this resonates with a lot of us. When we're in a hot state, when we're in an emotional state, sometimes we say things or do things that we regret. In contrast, the emphasis on reason suggests that if you're cool and detached and make a calculated reasoned judgment, you might achieve a better approximation of justice. At least that's the idea in our system. So I think what he was trying to say there is this is an emotional case. People feel strongly about what Michelle Carter did. If I were to react emotionally to this, maybe, and I'm reading between the lines here, maybe I would come up with a harsher punishment than if I took a more dispassionate, reasoned, measured approach. I think that's what he was getting at. But going to your first, the major part of your question, Jillian, judges aren't required to excise emotion from their decisions. It's just part of the pattern that many judges and lawyers have become accustomed to through law school and practice.
Gotcha. So right before the judge delivered his sentence, he told the court that if they want to understand the juvenile court system and want to understand, the process that he went through to sentence her, he referenced reading a document that had been put together in 2016. And I guess it was about the juvenile court system in Massachusetts and sort of how it's unique. Do you know what he was referring to by any chance?
I do.
Oh,
back in 2016, our Chief Justice of our Supreme Judicial Court, Ralph Gantz, who's a terrific judge. He is very devoted to best practices, to making the Massachusetts system as good as possible. I'm a big fan of Ralph Gantz. And Ralph Gantz basically asked lots of judges in various parts of the system to develop best practices for sentencing. And he convened a best practices working group that was led by a very prominent and bright juvenile justice judge named Jay Blitzman. And they came up with this document that Judge Moniz referred to last week that basically talked about what are the appropriate metrics, what are the best approaches for sentencing youthful offenders and delinquent offenders, juveniles who have these particular designations. And the upshot of the report, I took a look at it, is basically to remind judges of the rehabilitative goals of the system, and that the objective, even for the so-called worst of the worst youthful offenders, is not punishment. It's not punitive, but to help basically launch teenagers on a path to becoming productive citizens. It's fascinating that Judge Moniz referenced this report because it's a very aspirational report. It really points to the idea that we should not punish, we should not lock up kids and throw away the keys, that we should devise sentences that are really designed to achieve individual self-improvement. It's a really remarkable report. And once Judge Moniz mentioned it, to some extent, it was a clue, I think, that he was going to come up with a somewhat more lenient approach.
Another thing the judge told Michelle was that she cannot profit from the case at all in any respect. He cited, and I think this was the case, I was kind of writing it down furiously, but I think it was Commonwealth versus Power from 1995. Do you know what that case is?
Yes, absolutely. So there was a woman, I think her name was Catherine or Kathleen Power, who participated in a bank robbery in the 1970s, a botched bank robbery that resulted in the murder of a police officer. She wasn't necessarily the shooter, but she was part of the team that was robbing this bank. Then she went on the lam and was a fugitive for more than 20 years. She was finally caught amidst great fanfare in the 1990s. It was a big deal locally. She pled guilty to a couple crimes, and one of the conditions of her plea bargain, Jillian, was that she agreed not to profit from the sale of her story to the media. She was getting a lot of attention at the time. News magazines and publishers were clamoring for her story. So she pled guilty. And then later, she had second thoughts about agreeing to that. So she filed an appeal that challenged that part of her plea bargain, and she claimed that it was an unconstitutional burden on her First Amendment rights, that basically she was being deprived of her free speech. The appeals court disagreed in a very interesting case. Basically, the court said that this condition only prevented her from profiting from the story, not from telling it. She could tell anybody about her story. There was no content restriction on her, just a financial restriction. So her free speech wasn't necessarily being suppressed. Her right to benefit financially from that speech was. And according to the court, that's fine. So here, Judge Moniz referenced that case basically to tell Carter that a condition of her sentence and her plea bargain is that you can't peddle her story to TMZ or the National Enquirer or whatever, right? She can tell her story. She can give interviews. She just can't make money from it. And I think that makes a lot of sense, right? We don't want criminal defendants in salacious cases to profit from their crimes, literally, by selling their story to the media. Because on the margins, this could, of course, encourage criminal activity.
Right.
So that's what the judge was getting at. And the Power case, at least locally, is quite well known.
Gotcha. So after he sentenced her, this is a part that I was shocked about. You probably weren't, but her attorney, told the judge and was kind of arguing for this, that there were significant appellate issues in the case. And he asked for a stay of her jail sentence until all of those issues went through the appeals process. So the judge ended up agreeing, which means that Michelle is not going to spend any time in prison until that's all hashed out. If I have that understanding correctly.
You're right.
Can you talk about how common that sort of thing is? And were you surprised by that, or was that something that was pretty expected?
No, I was surprised because it is quite uncommon. But I think the reason why the judge did it, and I've reflected on this a bit, I think it had two reasons. First, appeals in Massachusetts often take more than a year to resolve. And in a case like this, with its complexities, I'm thinking a year to 2 years to resolve. So perhaps it struck Judge Moniz as unfair for her to serve time behind bars when the case could, in theory, be overturned, because it was a short sentence. Maybe in the juvenile system, this is more common than I'm aware of. Again, I'm not an expert on the juvenile justice system.
Right.
But the second reason, and I think this is more interesting, Jillian, is that his decision to grant the defense lawyer Cataldo's request for a stay might reflect Judge Moniz's perception that the conviction is vulnerable on appeal. Maybe he thinks that this is going to be overturned by our Supreme Judicial Court, and he thinks that basically as a matter of fairness, you shouldn't put someone behind bars when the conviction is going to be overturned. That is fascinating to me. The judge perhaps thinking that his own decision could be vulnerable on appeal.
Right. That was another thought that I had too. I was wondering, I wanted to ask you that too, if that maybe, if that kind of shows that the judge wasn't so confident that the conviction was going to stick. Yeah, that's definitely fascinating.
And it could signal that. You're exactly right, Jillian. It could signal a lack of confidence. Now, that lack of confidence could derive simply from the fact that this is an unusual case and basically what's known as a case of first impression, sort of the first time we've seen something like this. So maybe he just thought, hey, I made a good decision, but who knows how that court's going to handle it, the higher court. Or second, it could actually mean he feels like he's on shaky ground, and he's somewhat confident that it might actually be overturned.
Right.
And I do think this conviction is quite vulnerable on appeal.
I remember you saying that last time. Have you come up with any other analyses about that?
As I've thought about it, and I've tried to really reflect on it in the last week in particular, I think that causation element is the most vulnerable part of the conviction. So again, for a manslaughter case, you have to prove the defendant recklessly acted, and here Michelle Carter acted recklessly with those text messages and her phone calls and telling Conrad Roy to get back in the car. She consciously disregarded a substantial risk, and that's recklessness in Massachusetts. But the question is, did her reckless conduct actually cause Conrad Roy's death? And as I've thought about this, here's what I think. I think she was the driving force. She was the pivotal factor. But ultimately, he was alone in that car, and he made the fatal decision to take his own life. And in criminal law jurisprudence, that's often known as what's called a intervening act, an act that breaks the chain of causation from a person's reckless act to the end result. So I think on appeal, the defense is really going to hammer that point home and argue that the prosecution failed to prove causation beyond a reasonable doubt because Conrad Roy himself, through his own actions, was an intervening act that broke that link.
Gotcha.
I'm less confident in the First Amendment claim, which a lot of people are talking about, that this case is going to be overturned because she was just being punished for her words. I don't think that that's going to prevail, in part because our highest court, the Supreme Judicial Court, already indicated that there was enough evidence here that the words alone were sufficient to go to trial. So I very much doubt that later it would say, even though it's enough to go to trial, it's not enough to convict.
Gotcha.
So I don't think the First Amendment is really going to be a winning argument for the defense.
And what about the fact that she had instructed him to get back into the car?
That's a big part of this.
Yeah.
That's an interesting point, Jillian, because that's something I think that the prosecution is going to emphasize to counteract the argument that Conrad Roy was an intervening actor, right? They're going to argue, hey, she pushed him into the car, basically, that her words were the equivalent of a hand on the shoulder. Get back in the car. And so really, he wasn't acting under free will. He was being pressured or coerced. And it wasn't an autonomous decision by him to take his life. I think you're absolutely right. The prosecution is going to emphasize that. But I still think the defense has a pretty strong argument here.
Interesting. And then I know we talked a little bit about it before, like earlier in our phone call, but what were your thoughts on the sentencing?
I actually think it's a good balance between the competing objectives of sentencing. I often like to think of sentencing as a bit of a stew. It's a mixture of aggravating and mitigating ingredients. So in terms of the aggravating ingredients, the ingredients that suggested he should throw the book at her, we have her high level of blameworthiness, her despicable behavior. We have something known as deterrence. We want to send a message to teenagers everywhere that this type of behavior will not go unpunished. You don't want to replicate what Michelle Carter did. Those are some of the aggravating factors. But in terms of the mitigating factors, first and foremost, she was only 17 at the time of the crime. And the goal of our juvenile justice system, as Judge Moniz emphasized, is rehabilitative, to help people become productive citizens. Also, her own mental health troubles were a factor that I had at least thought would be significant. Judge Moniz discounted them in his statements. He said that he didn't really emphasize that in his considerations. But that's why I think that this type of sentence, some jail time, but not too much, was probably the right balance. Though I'm sure a lot of people will quibble on the margins. Mm-hmm. Some people would say she should have gotten 5 years or 8 years. Others might say she really is just being punished for her words. She should have just gotten probation. I actually think this was a pretty solid middle-of-the-road sentence. And it was also quite magnanimous of him to sentence her to the House of Detention, to Bristol County, as opposed to the state prison. He could have gone either route, and I think the reason he may have sentenced her to a local facility was to allow her to have access to her support network, to her friends and family, which makes a lot of sense if indeed rehabilitation was his principal goal.
See, I didn't even pick up on that, maybe because I'm not local to that. So yeah, I didn't even realize that he had sentenced her to a local jail aside from a federal one or a state one.
Yeah, so I think it is quite significant. So I know you're from the Chicago area.
Yeah,
you can imagine the difference between being sentenced to the Cook County Jail right in Chicago, if you live there, and being sentenced to Illinois State Prison, which, if I recall, is down. There are a bunch of them downstate, quite far removed from the city, mm-hmm. which could pose major obstacles for family members and friends to visit you. Here, the judge could have gone for the state prison, and there's one major women's facility in Massachusetts, which is not especially close to Michelle Carter's hometown, or he could have opted for a local solution, and he went for the local solution.
There's no telling how long Michelle's appeals process could take. It could take months, and perhaps even years. And that's all for today's update. I want to thank Daniel Medwed again. Please go follow him on Twitter at Daniel Medwed, which I'll include in the show notes. As always, to discuss any of these cases, please consider joining my Facebook discussion group at courtjunkie.com/Facebook. Follow me on Twitter at courtjunkiepod, on Instagram at courtjunkie, or you can always email me at podcast@courtjunkie.com. And thanks to all of you for listening. Until next time.